4 volumes of docket, 7 accused, 6 generals, and 1 prosecutor who says he could not find a single piece of evidence of corruption in any of it. Today, Advocate Peter Serun, a Deputy Director of Public Prosecutions, 31 years in the prosecution service, sits before the Madlanga Commission and does something you almost never see. He turns on the head of his own unit. Advocate Andrea Johnson told this commission that nobody in her office ever raised concerns about the arrest of Lt Gen Dumisani Khumalo and 6 crime intelligence officials. Serun's answer? She was not being truthful, and I'm saying that with the utmost respect. He asked in writing on a Saturday who corrupted whom. He says he never got an answer. He says a magistrate had already refused the first arrest warrant. He says the Section 27 referral, the document that started everything, was held in front of him and pulled away. And when he finally read it, it wasn't the Section 27 at all. It feels like our setup. Nobody has been convicted. The charges were provisionally withdrawn. But what this man says under oath today changes the story. Like, subscribe, hit the bell. Let's go inside.
Advocate Serun, the last sentence of your paragraph 20. Good morning. I don't think I greeted you. Good morning.
Good morning, Commissioner.
Paragraph 20, the last sentence, you say every matter is headed by a DPP who acts as a project owner.
Indeed.
Are there exceptions to that rule, if it's a rule at all? Because the matter you're talking about next, as I understand your statement, it was not headed by a DDPP.
Yeah. There is no exception to that rule.
Or there should not be.
There shouldn't
not be exceptions.
There shouldn't be.
So where there are exceptions, what is the problem and what is the reason for that?
The only exception that I know of is with this case, and I cannot explain it. I always believed that each case is going to have or must have a DDPP, because there are functions that a DDPP must do as the investigation unfolds. As I indicated earlier, when we need information from the banks, from cell phone providers, and so on, we serve them with a subpoena. That subpoena can only be signed by a DDPP. And if a group does not have a DDPP, I cannot see how they are going to be able to proceed.
And that's the whole point of a prosecutor-led investigation, that you need a senior prosecutor overseeing and guiding that investigation.
That is true, Commissioner. That is true.
So where that doesn't happen, what is the issue? What is the problem? I'm trying to understand. Because the case you're going to deal with, you're going to give us facts, but I'm more interested in reasons.
Yeah.
When no DDPP is appointed to head or to be a project owner of a matter, what could be the reason?
Commissioner, I find it difficult to explain. Because that shouldn't happen. That shouldn't happen. Otherwise, investigations are going to stall. They are going to find it difficult to get information from service providers. And in such a situation, you also don't have leadership. You don't have anyone guiding and helping the team, and so that they can wrap up. Everybody's going to do as they please. So that's why you need a leader in the form of a DDPP to help direct the team.
It's like a soccer team playing a match without a coach.
Indeed, Commissioner.
It can happen, but it shouldn't happen.
They are going to kick the ball all over without any direction.
I think you were to start I established that she was appearing. Or
yes, I then established that Advocate Tlachwayo was appearing in court that morning with investigating officer Mr. Brian Padayashi, and that there was no co-prosecutor with her in court, no senior state advocate, no DDPP, and no chief investigator assisting her. I was concerned that a matter of this magnitude involving the arrest of senior members of the police was being handled without such support and without a DDPP overseeing it. At that moment, yes, I then, together with one of my fellow DDPPs, Advocate Jacinta Vetboy, and Mr. Sibusi Sochikovi, who is the chief financial investigator. These people, I'm mentioning them because they were in this group when we were inquiring and making and trying to find out who was handling this. We then decided, the three of us, we then decided to approach the head of the unit, the investigating director, Advocate Johnson, to request permission to attend court to assist Advocate Latchwayo. On arriving at her office, we found that the investigating director had not yet arrived, and we left a message with her personal assistant, Ms. Innocent Sikukuni. On my way back to my office, Ms. Sikukuni telephoned me to say that she had discussed our request with the investigating director telephonically, and that the investigating director had agreed that we could attend court as requested. Among the conditions imposed by the magistrate was a condition that the accused do not enter the premises of crime intelligence anywhere in the country. Neither the state nor the investigating officer had requested that condition, and the magistrate gave no reasons for imposing it. Of significance is that in the course of granting bail, the magistrate himself remarked that he was not persuaded that the state had a strong case, and indicated that this was among the consideration that moved him to admit the accused to bail. He observed that the matter was not a typical fraud or corruption case. This doubt was expressed by the presiding officer at the very first appearance. It's there on record, Commissioner. The magistrate says it after asking Advocate Latchwayo some questions. He says, I'm not that convinced that your case is that strong because it's not like the typical cases that we deal with of fraud. And he also says it to the accused when he grants them bail. He says one of the things that I've considered is this issue, and I'm not convinced about the strength of the state case as it stands, based on the address by the prosecutor. The record speaks.
Was that not a concern for you? For such a big matter, we're talking head of crime intelligence in the country and other generals at SAPS.
Commissioner Khumalo, it was a concern, and that is why I asked to go to court to assist. But I did not think of involving myself beyond that that point after the bail application was done, because I did not know why is this team so small. I did not know how it came about, but what I know is a case cannot be handled or done in the IDAC without the ID knowing. Therefore, I don't know how this team was composed, but honestly speaking, I didn't want to get myself involved in why was this done, why was not, because I was not part of the team at the time.
You give the impression that you did not want to step on the ID's toes. You did not want to ask her difficult questions. So you said, if she made the decision, I will live with it. I won't even question it. That's the impression you are giving me.
And I'll agree to that, Commissioner. Because as the head of the office, you would have made decisions. I can't ask questions on, especially questioning how this team was composed, why not involve me, or why not involving Advocate Polo, who was overseeing this. At the time, I didn't ask myself many questions on the composition of the team, but it didn't look right to me that a case of this magnitude was, on the day of the arrest, handled by a junior. I didn't take it further than that, but it didn't look right. One of our colleagues, even this morning, when we were having tea, that it appears I sort of found myself in an offside position, or at least handled a ball with my hands. In fact, I sort of feel a little bit angry if I think about it, that it feels like I was set up, not only me, but Latchwayo as well. I think junior as she was, I don't think she was supposed to have been involved in this case And looking at it now, it appears to me she was set up. I think somebody informed her that I'm asking this many questions about the Section 27, and I think I'm dealing with it on the affidavit. There's a stage where the ID called us to a meeting, me, Advocate Ramsey, and Advocate Tlachwayo. It was also a very short meeting. It was about during lunchtime. And when we got into the boardroom, she was already seated there. She looked very angry, I must say. And immediately when we sat down and she addressed me, the meeting was about her addressing me. She said, Serun, I hear you are looking for a 27. You're asking many questions. Don't you believe my investigators? And she said, I have seen the 27. The ID has seen the 27. What more do you want? And I said, but ID, I'm the designated DDPP in the case. And I'm told this case came via referral. I want to see this document. And the accused are also asking for it as part of the disclosure or application for further particulars. And she said, no, guys, go back and work. The ID has seen this document. Okay. So that was the end of the meeting. Paragraphs 3.4 and 3.5 above. Why did these generals in the SAPS go out of their way, rig the appointment process, risk their jobs, and flout the National Instruction 11 of 2017 to appoint a 29-year-old inexperienced civilian to the rank of brigadier in crime intelligence? I'm asking the question, who is this young lady, in bracket Mokwele, for whom 6 generals in the SAPS are risking losing their jobs for? What did the generals stand to gain or expect to gain, in bracket quid pro quo, by giving her gratification, which is the position or the job? What did they stand to gain? I don't have that evidence in the docket. 3.8, what are we saying? Are we saying the generals gave Mokwele a position, stroke a job in crime intelligence in order for Mokwele to do the following? To do what? I'm asking them. What did Mokwele have to do in terms of Roman figure 1 to 4 of Preka?
I say that tongue-in-cheek. Yes. My question is, your memo seems to me at least, to cover or to raise questions that I would expect a prosecutor to ask before there is an arrest, before there is charging and people are made to appear in court. You seem to be asking basic questions. Am I correct in that observation?
You are 100% correct, Commissioner Baloyi. These questions, the team ought to have asked themselves these questions. When I come in 2 months after the arrest, I was not supposed to be asking these questions, especially if a person is charged with, that's what I'm saying, why did you charge them with corruption? Because I'm looking for the evidence of corruption in the 4 volumes in the docket. I can't find any evidence of corruption. Postponing for investigation.
Is it fair to say that your memorandum, the questions that you're raising, suggests that your view at this point was that you don't even have a prima facie case yet, at this point?
Clearly there isn't a prima facie case. When I asked them, for the first question, why are the accused charged with corruption? You know, who corrupted who? I can't see it. There's no corruption. Who corrupted who here? So there's no prima facie case, not even on the lowest standard of corruption. There isn't.
Did the ID engage you about this memorandum where you're saying we don't even seem to have a prima facie case? Did she come back to you and tell you, no, you're wrong, we do, and these are the reasons?
But now, Commissioner, I was never engaged by the ID on this memo. At least the investigating officers tried to respond to some of my questions.
Yes.
But what they did basically was just to recite what the Act says, and not to deal with the questions.
Thank you.
Because you say even the arrest warrant should not have been issued on these facts.
True. Indeed, Commissioners, on these facts, there was no case. It couldn't have been. And maybe on the issue of the warrant, Commissioner Khumalo, when I first read the docket, because the statement applying for the warrant forms part of the docket, I remember having a discussion with Advocate Lachwa and asking her how did the magistrate authorize this? And I remember she told me on the first occasion when Brian Barayashi went to court to ask for a warrant, the magistrate turned him away, saying a statement.
So the one that was issued was the second one?
It was the second one to try.
There was one where the magistrate refused to grant the warrant, to issue the
There's
warrant.
one where, yeah, there must be one where the magistrate refused to issue a warrant, because the magistrate was not convinced that there was a case. The magistrate who sits and does this, so the magistrate sent him back, and he went and compiled another one, went back, succeeded with the second one. But still, when I looked at the second one,
to show Mr. Simon the national instruction and to say to Mr. Simon, please tell us what Ms. Mokwele was doing at BMW. Is it experience at a level higher than the supervisor? And what were those functions? What they went there to ask was she in senior management for 7 years? That's a wrong question.
True.
And to then go to court and say she must be arrested for fraud because she doesn't have 7 years senior management experience. Before we even get to the charge sheet, just asking the court to authorize arrests on those facts, that is problematic.
I concur, Commissioner Khumalo. These are things that it goes back to my earlier position that the investigation was rushed, or at least the arrest was rushed. These are issues that ought to have been dealt with and determined.
Lawyers, an office which has many lawyers, whether no one ever raised concerns about the strength, whether firstly, whether this matter falls within IDAC's mandate, but two, the problems that we were discussing with her. You've discussed some of them with Commissioner Khumalo. What is gratification? Ms. Mokwele seems to have met the requirements. How do you have a charge of corruption and a precar gratification when you say that she would have done something in the future which is unknown? All of those were discussed with her. And then she was asked more than once, does this mean no one in your office ever raised concerns about this case, the merits of this case and the mandate of IDAC? And she firmly said, no, no one ever did. None of the lawyers. What do you say to that?
With respect to Advocate Johnson, I did. I raised, I think earlier we read one of my emails where I referred these queries to her. And it was not only that one email, but there's two, maybe even three others that I referred to her, where even with the Lushaba case. The Lushaba case is worse. That's why I'm saying. So I did. I don't know if maybe
she was not being truthful.
Maybe she did not have my email communications to her, but I did. I raised my.
Do you have reason to doubt? Do you have reason to doubt that she received your emails and your memos?
No, she received them.
She received them.
I can confirm, because once I send an email, innocence, and there's one email, for example, where she responds to me, when I'm asking her, should we serve at 28, or is this office, referring to her office, going to write a letter to the National Commissioner? I send it to Innocentia, but the ID then responds to me, says serve at 28. So, and when I send an email, and this is the practice in the office, to the PA, if you see that you're not getting a response, you make a follow-up with the PA. Did you give my email to the ID? Sometimes you go straight to the ID's office or call or send the
So
email to her.
in short, she did become aware, she was made aware of concerns about this case, the Lushaba and the Mukwele matters.
She was. I did that personally.
And
I made her aware.
she was not truthful to us if she did say to us, as I say she did,
Yes.
that no one in the office raised concerns about this. She wasn't being truthful.
Commissioner, if that is what she said to this commission,
Then she was not being truthful.
I don't agree with that. I
She was not being truthful.
She was not being truthful.
Thank
And I'm
you.
saying that with the utmost respect.
I
for
appreciate,
her.
I understand that.
Yes.
Thank you. In this paragraph, firstly, what I have a difficulty in terms of how I've understood your processes is you are past section 2813 because there's been a decision
True.
to investigate. You investigated, now you've charged. So you're now in the realm of court. And you, DDP, hold the view that as matters stand, we have nothing. And then in the last paragraph, you say, let's go search. And it seems to me that now what's going to happen with that last paragraph is to meet or satisfy a theory that has been formulated. We have nothing to work with, but our theory is these generals are corrupt. Let's go find something. And you can explain it. And if that's what's happening here, it seems to me that even on your own email, you are participating in an inverted process where what is the stage of things? You are in court. These people are appearing. Why are you saying we don't have a case, but I'm sure if we dig some more, we'll find something? That to me, on the face of it, is deeply problematic, but also your position, it's inconsistent with the position that you take earlier on where you say we don't have a case. And then you say, but I'm sure if we search, we'll find something. That's not like a typical fishing process. Can you just explain how to make sense of your contradictory positions and what I suggest is a fishing expedition that you're suggesting should happen. And it's not simply a fishing expedition, it is in fact an abuse of your investigative / prosecutorial powers.
Know at what stage he was appointed, and what I know is with the evidence of the former ID 2 weeks ago, we got together, me and Manilal and Hlachwayo, and the two other prosecutors who were now part of this. And our decision was, based on what came out after the evidence of the ID, there's no way that this case can be saved or resuscitated. And we then asked for a meeting with one of the deputy directors, national deputy directors. We met with her and we said to her, we know now that the matters are seized with the NDPP, but this is our proposal. And I forgot her name now. I think it's Advocate Bell. And I know that Manilal thereafter penned a memo to them based on those discussions with Advocate Bell, setting out our views. And then we were overtaken by events where I heard that the NDPP has decided that the cases must be provisionally withdrawn. Yes.
Thank you. Because you would have heard from evidence that, rather when we were engaging with Ms. Johnson, that there was a question of, but why was this done? This which looks so obviously wrong, why was it happening? Commissioner Khumalo went so far as to say there's a third, either he said there's a third hand or a hidden hand, it looks like, because things don't make sense. How this team of investigators and lawyers would do something so obviously wrong on the face of it, and that doesn't make sense. if I read paragraph 1 or understand it correctly, you're repeating that which you've criticized. You can correct me if I'm wrong, but you seem to have repeated that which you criticized by saying they granted gratification to Brigadier Mokwele. And I'm trying to...
I can see now that, maybe.
Commissioner Baloyi says the reason you put it there as the main count is because you knew that if you started with the alternative count, then IDAC does not have, this does not fall within IDAC's mandate. So you had to put PRECA as the main charge to justify IDAC continuing to prosecute this case.
No, I respectfully disagree, because that will then question my motives, and I come in here with clean hands. I came in to rescue a situation. I've never, since I was involved in this case, involved myself in any shenanigans, and I stand here, I can say with a clean conscience,
you know,
I did my work to the best of my abilities.
A prominent South African once said, "My hands are clean," and we know what happened next.
I do, Commissioner, but for me, listening to the evidence, and like I said earlier, hearing what I've heard here, I wish, and as I was saying to somebody during lunch, I wish I could turn the hands of, back the hands of time, and I wouldn't have gone to court on that day, on the 27th, when there was a bail application on 27th of June, because here I am now, in the middle of something that I did not start. But what I can say is, I realized when I came in that this case was rushed to court. It was not ready. I raised those queries, and I wouldn't have prosecuted a case like this if it was not ready. It's a pity I recused myself before I could make that decision. Otherwise, I would have made it. My affidavit, paragraph 64, some days later, that will be now after the 31st of October, following a management meeting, the chief investigator, Mr. Daylan Perumal, informed me that he had the Section 27 referral and showed me a document in his office. He showed me the document whilst holding it. It was as if he wanted me to see its existence, but not its contents. If I can
what exactly do you mean by that? It was as if you wanted me to see its existence, but not the contents. How did he hold the document? Did you get to read the document? And based on what you are going to say shortly after this sentence, it seems to me that you actually did read the document, because you even estimate the number of pages, and you also suggest that you actually saw the content.
Why do you not insist that it be made available to her if you know that she must look at it because there are serious issues with it?
Because, Commissioners, as I said earlier, there was a meeting where the ID called me and the two prosecutors, and I was told to back off from demanding this Section 27. The ID says, "I've seen it. Are you not believing my investigators?" So I was not going to ask for a copy of that, because I got clear instructions: stay away from this, just do your job and leave the...
So you were scared of the ID. That's why you did not insist that it be made available to the prosecutor.
If one, I cannot dispute that. I didn't want to upset her. She was clear. I have seen the 27. I'm satisfied that it exists. Leave this matter alone. I hear that you've been asking a lot about it. Leave this thing off. So when Mr. Perumal showed it to me that day, we were coming from a meeting, and I did not even demand a copy, because I knew I don't have to deal with this document. But at least I've seen it. And again, remember, I was no longer part of the case, in fact, by then. This is now in October. I've since been recused in 16 September.
Is that what you saw, just
This
below
is what I
Mr.
saw,
Adams's name?
Commissioner Khumalo. This is what I saw on the day.
Do you see it says dated and signed to at Pretoria on 6 January 2025, and then it says in my presence in Cape Town?
Exactly.
Is this what you were shown?
That this is the one that I saw, that Perumal showed me.
But then this is not the Section 27 affidavit that started the whole thing.
Then he showed, this is what I was shown. And that is why I'm saying, after reading what was shown to me, I did not make anything of it because it was not saying much. It was like a 2-3 page statement, which really didn't say much. And I was amazed why has it not been shown to me all along? Because it's not containing, sensitive information that I was not supposed to see or anything. If they've given me this all along, I would have stopped asking for it. If
Mr. Perumal showed you this document and said to you it's a Section 27 referral, he misled you because that this is not the referral. This is a statement that was taken and marked A1 by him.
He would have misled me, Commissioner. That is what I'm saying. After reading what he showed me, it was like I was reading one of the affidavits of Mr. Adams, which I saw in the docket. It was similar. So when one says, oh, here's that 27 you've been looking for, I hear you've been asking questions about this. So that maybe I should stop asking. There isn't.
To the accused. And that has consequences. It could be any other document from where I'm sitting, that if on something like this you have a head who says, no, we're not disclosing that, it's an internal document, and everybody around her knows that what she's saying is not correct, but they comply, then it doesn't give faith that on any other matter, if she says that we are not disclosing, that her prosecutors will not say, well, if I must lose my job, I'm going to lose my job, but my integrity and my responsibility to my profession and to the court is that I make disclosure. That has a sense of discomfort about it. And either she was particularly powerful, and so nobody dared to say, but that's breaking the law when we do that. Or she works with prosecutors who are okay to look the other way, which is deeply problematic, and I don't know which is worse. But that's the sense that, that a sense of discomfort.
I understand that.
That all of this creates.
I understand that, Commissioners.
Thank you.
Just to complete the picture, the Section 27 that you were shown, the one that we find in File 2, we know that on the 9th of October 2025, it did not exist because in File 10 on page 402, you don't need to go there. There was a scramble at IDAC offices because people were looking for the Section 27. And Ms. Ramsemi was asked about it, and Mr. Perumal inquired about it. Nobody knew where it was. And they thought she had it, she had kept it since December the previous year. Even when Advocate Johnson went to the ad hoc committee in October or November last year, she could not produce it. She raised various issues, but the simple point is on the 9th of October 2025, Mr. Perumal did not know where the Section 27 was, and everybody in the office was looking for it. And they actually thought it is missing or it has been destroyed.
Yeah.
Let me add to what
Yes.
There's in fact now controversy about what is the Section 27 affidavit that started this investigation. You have followed that evidence, so more the reason why you would expect, and I hope for my part that those who are listening, your colleagues, they understand from this evidence that we've set through why it's important for the lead prosecutor to have sight of that Section 27.
That's true. I agree, Commissioners. Really, I felt, I don't understand this type of charges. And I wrote that down. I think I have one of the emails where I was saying, what has this man done? What is the crime that this man committed that warrants him being charged for fraud and defeating the ends of justice when he's actually a victim of what appeared to be a syndicate? Because it comes out from the investigation that this lady and a group of people were doing those kind of things in the local places in around Pretoria, where they were dragging victims and robbing them. It appears the very same lady had a warrant of arrest issued for her in one of the courts for doing the same thing to one of the victims. And you can see General Lushaba's bank card being used the following morning after he had lost it. So somebody was buying liquor all over using the card. So I found it difficult how this man who had lost his items should suddenly then be charged. And it is on that basis that I said in the meeting with Mr. Soko, this is not the case. I don't know how everybody arrives at this. And I then repeated it and I sent an email. Looks like it. And that is why, like, sitting here today, after listening to all the evidence, it appears, and I can see it now, that some of us went in, we were just doing our work, but it's painful that it appears there were things happening behind our back which we were not privy of. And it appears to me that some of us were used. If you're given instruction, go and oppose a 63, you go in, you think you're doing your work to the best of your abilities, you go and oppose a 65. I mean, I did 2 cases. Out of this case, I went twice to the High Court with the recusal application and with the 65 bail application, doing what I love, what I've been doing. In next month, it will be exactly 31 years, without knowing that there's other things happening behind the scenes. It's painful, but I didn't know at the time.
Thank you.
I didn't know.
I was misled. My people failed me. We went to court. So colloquially, she's throwing you under the bus, saying, are you saying you disagree with her that which she said should have happened, that you should have gone back to the magistrate. On appeal, you should have been the one that volunteers to the court, that this is what happened in the lower court. Are you saying she's wrong when she says all of that?
Commissioner, what I'm saying is, indeed, she's throwing me under the bus in that she got me into the case to oppose the 63 bail amendment. But when she comes before the commission, she says something else, that as if I was doing things on my own. If she didn't instruct me to be part of the case, I wouldn't be sitting here today. She involves me in the case. I don't know what the brief to her was by Tlatrayo, but she says specifically, because there's a senior lawyer involved there, I want a senior person to oppose this. It happens, the powers are with the magistrate. It appears the IDAC wanted that condition. The head says to me, go and defend this. I can't say to them, no, why? And so I did that, and the amendment was abandoned, the application was abandoned. The Section 55 is brought in. Again, I'm giving instructions to oppose the Section 55 bail appeal. So I'm very sorry for the head to come before this commission and say, portray me as having acted on my own without consulting. It's just not true, and I did not take kindly to that, because she brought me into the case for a specific purpose, to oppose the application and to oppose the bail.
It's a coincidence at best that a condition, on your version, a condition that was not asked for by the state, in fact gets, and is not raised in open court, gets given by a magistrate, and a condition of this type, which is these accused are prohibited going to any crime intelligence office across the country. But two, the consequence of that condition is effectively they get suspended from their offices, from employment. It's quite a coincidence.
It is a very strange coincidence. I agree.
You accept that?
And if one looks at the evidence that is now before court, really one cannot rule out anything. But unfortunately enough,
Have been discussed with the magistrate before the hearing started. Is it possible that the prosecutors went to the magistrate chambers and said, look, this is what we are going to ask for? The reason I'm asking you this is you have just confirmed that it is a condition that Mr. Padiaki and the prosecutor had discussed before. So on their way there, that's what they wanted. It was just not discussed in open court. And then it becomes a coincidence that the very condition that they wanted, but they did not ask for in open court, is a condition that is attached to the granting of bail. So where else could the magistrate have got it from? And a condition that is so specific, if they had not discussed it with the magistrate, either during the hearing or prior to.
yeah. Yes, Commissioner Khumalo, one thing for sure, it was not discussed